I'll tell you what you will love. The guy, this is my little guilty pleasure, is going on the web and YouTube and finding all the places from overseas, in London, in England, in New York, and then in different stations across the country, Los Angeles, etc., where David Katz appears with his legal mind analyzing really complex legal situations. You hear him on London radio. You hear him on and see him on London television. And as I say, across this great country, most grateful that he spends time with us. Happy New Year and a welcome to the former federal prosecutor, now working the defense side of the table in California. How about it for David Katz, everybody?
Happy New Year, everyone.
Happy New Year, sir. Very, very cool. And wow, you have met your moment. 2024 looks as though it will be problematic and provocative from a legal perspective. I want to ask you first about a story that you, in the first hour, there were many saying, well, this is a non-story. And you could say that there are parts of the Epstein thing that is sort of a non-story and that we knew a lot of these various characters were associated with Epstein, meaning they might have ridden his plane or whatever. And I was speaking about guilt by association. And you can speak to this as well. But I also want to talk to you, or at least get a thought from you, about how this stuff, these private associations that people have with Epstein or anyone, just in general, become public, and how the public need to know trumps whatever right to privacy people have.
Well, great to be with you. And, one of the reasons that they're so interested in the United Kingdom about this story is, of course, the Prince Andrew connection.
Sure.
Prince Andrew, it's been reported, settled for a multi-million-dollar amount with Virginia Giuffre. And she's the one who started, along with others, of course, but she's known for having started this civil litigation with very good lawyers. And of course, Jeffrey Epstein's story is an interesting one as well as a frightening one. I mean, being a sex trafficker is a terrible thing, and having become so prominent. And what was his relationship with all of these very wealthy people? And how did he go from being a high school dropout to being worth millions and millions of dollars and owning supposedly the most luxurious, urban mansion in New York City? And then, of course, all the famous people who flocked around there. And they're going to say, Mark, that, they really didn't know, especially the ones who didn't enter the mansion. And so that is very important. I mean, what we have right now is a sort of a name and shame. And, there's all kinds of celebrities who've been brought in there. And you really think they probably just flew on a plane one time, or maybe there was a question asked about them at a deposition. And, this latest document dump is the 8th tranche of information about this case. And the reason it's been 8, and it looks like this will be the last one, is because we do seal records. Now, let's get into this issue about how we seal records. So somebody files a civil suit against somebody else. We have this idea of public courts. When there's a trial, we have this idea that any member of the public can walk into the courtroom and see what's going on. And any member of the public or the press could go look through the documents in the case, in the file, or now go see them online. We file public. When I file as a federal criminal defense attorney a motion about my client, generally speaking, the whole world can see it. In fact, lawyers who like my writing style or analytical style can poach some of my great lines. It's public, right? It's just one of those things. It becomes like a template. And I've looked on there and seen, some of the great criminal defense attorneys, how they phrase certain things, and they're public. Anyway, the problem, though, there's a couple of things. First of all, we do protect privacy in obvious ways, people's social security numbers, maybe a date of birth, anything that would help an identity thief. You actually have an obligation as an attorney to redact that before you submit the document on a public file. If you have a youth victim, and of course, this case is replete with youth victims, young women who were trafficked. We don't want their names to come out. We don't want their whole lives to be, under the shadow of their name or their date of birth having been released in a court pleading. But beyond that, we do have this idea that it's so humiliating. It's such a loss of reputation to even be mentioned in one of these cases. And that's how we got to this point. That's how we got to 200 names, 150 names being redacted. And so at each point when the press and, the Miami Herald really followed this case, they were tenacious. They deserve a lot of praise. Let me just digress for 1 minute, because they keep mentioning Clinton and somehow using this as a cudgel against Democrats. First of all, Trump's name is in there prominently. But on top of that, you look at the Jeffrey Epstein saga. He started off being investigated down in southern Florida, where he had this mansion in Palm Beach. He started being investigated down there for this sex trafficking and so forth. And the federal prosecutor gave him a non-prosecution agreement. The case just went to state prosecution, and he had a guaranteed sentence of, let's say, a year, 15 months. And he was allowed to be on home detention. That's been a notorious aspect of the case. But the U.S. attorney who agreed to that sweetheart deal and to the non-prosecution of Jeffrey Epstein went on to be in Trump's cabinet and then had to resign in disgrace from Trump's cabinet. So, Trump and Clinton, this is not a partisan thing at all. And then after that, he was able to go to New York City. I guess he was already in New York City, but to establish himself. So some people say, well, I didn't know what, he was up to. And of course, anybody who wanted to check could have checked that he did have this criminal case down in southern Florida. It wasn't a federal conviction, but certainly he was a good person to beware of, right? And these people who didn't beware of him and who should have known better, of course, they're all kicking themselves. But that doesn't mean the fact that they've been named and shamed, that they were involved in any criminality. In fact, they were not involved in any criminality as we understand it. These people were not prosecuted for anything. And some of them, it looks like, for real, we're on humanitarian missions over to Africa and other places like that to distribute necessary drugs and to distribute aid over there. And Jeffrey Epstein's in-kind contribution was to provide the plane and the pilot. So if you want to go deliver malaria drugs and your former, UN representative Bill Richardson, okay, it doesn't mean that you stopped on the way back at the so-called sex island of Jeffrey Epstein. You went on the flight, you came back. Clinton went on the flight and he came back, and it was a great thing for, humanitarian charitable purposes. And, as to him being on this sex island, former President Clinton, the flight logs don't back up that claim that he was on the sex island, and the Secret Service records don't. Now, you can have any idea that you want that somebody thought ahead to, excise or not create those Secret Service records, but it just seems improbable. And so everyone is not only presumed guilty, but really and truly, you have to always emphasize that while this is certainly blame and shame, or name and shame, and nobody would want to have their name in there, it really doesn't mean that there was any criminality or even any civil liability or any wrongdoing just because someone's name is in there, Mark.
I kind of was making the same point, this guilt by association thing, and I love the fact that you call it name and shame, because I think that's exactly what it is. I just wonder, though, David, just to my question, why and how you've mentioned the way certain things like Social Security and other personal information is redacted, why these names also don't enjoy that same privacy. Again, because of the shame factor, isn't there a damage done to be, and I don't mean to speak on behalf of rich people and politics, I'm just talking about generally now for all of us. Isn't there a shame factor that people have to endure just by virtue of the fact that they're mentioned as having in some way showed up on the plane of this guy? But why is their privacy not protected?
Well, there's about 150, 200 people who've been named at one point or another. In this latest tranche, there are some additional ones. And of course, every time a new name surfaces, you're right, that's a new person who gets named and shamed. First of all, if you don't have a lot of money, it's very difficult to stop it. Just as a practical matter, because you have to hire a lawyer. With this federal judge in the Southern District of New York in New York City, with this federal judge, what she did was you could go in front of her and object. And basically, you take a look at the document that they're about to unseal, and you could say, hey, wait a second, there's this wrong with it and that wrong with it. But I think the argument that, it mentions me and I didn't do anything wrong, I think the answer to that is when it comes out, you tell that to the press and to anyone else. It names me, but I didn't do anything wrong, if that's your only reason. But you have to hire a lawyer to make that objection. And if you don't like it, you have to hire a lawyer. You don't like her ruling. which is going to be unseal it as to you, then you have to hire a lawyer to go into the Court of Appeals. It's not a criminal case. You don't get an appointed lawyer. And there are some people who are at the appellate stage or are still in front of her. So let's say there are 10 or 12 people whose cases are on appeal, whose cases are in front of her. They have not been named yet. And it looks like there will be some people who maybe will not be named. And I don't know if you can make the argument, for instance, that I have a credible threat against me because of this or because of that. You know, I teach in the school system now. I'm going to be fired. I imagine some people are making claims like that. And maybe those will be valid. But generally, Mark, we have this idea of public courts. If somebody
it's the public. It's the public courts part of this that just makes it impossible to evade exposure as someone who at least knew the defendant in this case.
And one last thing, the Miami Herald has pushed this very assiduously because the Epstein criminal saga sort of is centered on Southern Florida. So they've got the lawyers, they've got the time, they've got the motivation. And some people think this is the great thing about our country. We have a free press that presses and presses. And so we don't have star chambers. We don't have, we don't have government out of the sunshine. We have things like this. But obviously in a case like this, and the judges had to balance that as she's going along, Mark. And I think she said in some the privacy interest, the fairness of not being shamed in this way has been paramount. That's why we're all these years down the road. This litigation started in about 2016. One of the interesting chestnuts that has come out recently is that they wanted to take the deposition of Bill Clinton right around the time Hillary Clinton was running against Trump. And he won a motion in front of the predecessor judge that he could not be deposed. And I believe that litigation was secret. I don't think that we've known generally that they tried to take Bill Clinton's deposition during the campaign between Hillary and Trump, and that his motion was granted. I think that would have been a huge story at the time. Clinton resists deposition. What insider judge, what deep state judge ruled in Clinton's favor? I don't think in general that we've known that. And you could say that, if you're a conspiracy theorist, you could say, wait a second, something was up. But, federal judges have historically been very, very fair, not partisan. I know we've had some arguments with the U.S. Supreme Court and people like Thomas on the Supreme Court. But generally, and this judge down in Texas, the judge, the one we lovingly call Loose Cannon down in Florida. But generally, the fact that somebody was appointed by picked by a Republican, picked by a Democrat, we've had pretty good success. Generally speaking, I don't want to be Pollyanna. So when I see something like that, I think that, former President Clinton had good arguments, not that somehow the judge was biased in his favor some way or the other.
I'm glad you mentioned the Supreme Court, and yes, assiduously is a ding word. I would ask you about something that's going on with Trump and the Supreme Court and judges, and you've segued almost perfectly into it. The questions that are associated with the insurrection clause and this 14th Amendment, which we talk about from time to time now because of the removal of Trump's name from the primary ballots in Colorado and in Maine. The question now is kicked to the Supreme Court, and then there's a question of immunity about this extends well beyond this issue of being on the ballot, and yet it's all about being on the ballot. The notion that the president is top of the pyramid such that he's granted complete immunity, he or she, in this case, he. It may go to the Supreme Court. It looks as though, it may go to a Supreme Court decision. You have, and you'll remind me, David, my recollection is that you had suggested that the Supreme Court may knock it down to the state level, or what so I need to be reminded of that. And I also need you to speak to the notion that the Trump people, through their surrogates, Maggie Haberman, for example, of the New York Times, Trump's lawyer who was appearing on CNN, they seem to be expressly making the point that Supreme Court appointees who are right-wing GOP appointees shouldn't bend over backwards to seem to be doing the politically neutral thing. They should do the right thing for America. It's like an express pressure that they're putting on the Supreme Court justices. So I've said a lot, asked a lot. Now you, please.
Well, I think there are two different cases that have kind of gotten conflated. And so, by some of the commentators, the presidential immunity, the idea that the president can do anything and that a president cannot be prosecuted for things that the president did in the course and scope of his or her duties. That's the argument in the motion in front of the court in DC District Court, which says that Trump can't be prosecuted criminally in federal court for the insurrectionary acts that he took, for the slates that he knew were bogus, for obstructing justice regarding the run-up to the election, after the election, and all the way up to the January 6th insurrection. That idea that he has presidential immunity, and Jack Smith just filed a motion where, or he filed his response to the president's filings, which said this can't be right. It cannot be that the president sicks the Department of Justice on political enemies. How about if evidence gets planted, or that's even part of it, to plant evidence? Can it be that a president can actually arrest, or do worse than arrest, to his main political enemies, and then say later on, well, I was just enforcing the laws? And particularly when it comes to the state elections that were being held, the argument is that even if there is some course and scope that the president can act in, like, let's say, making a treaty or encouraging the military in a foreign country, for which the president cannot be prosecuted. Let's take the example. Somebody right now, someone comes along and they want to prosecute Trump because Trump over-favored Netanyahu. He didn't rein in Netanyahu's settlement policies. He didn't rein in him trying to change the Supreme Court. And they can prove that Trump did that. Well, that seems like something in the course and scope, which is different from him sicking the Department of Justice, or even having the Department of Justice conniving and then planting evidence on a political rival, or arresting without any justification just for political reasons. So those two seem to be different. And that's why I think that the courts, including the DC Circuit that's about to rule, I think they're about to rule that there is no presidential immunity as such, and that the Supreme Court will probably stay away from that case. It's very hard, to predict the future, as they say. But I think that that's what's going to happen in that case. Totally separate from that, Mark, is the Colorado Supreme Court having said that Trump cannot appear on the ballot in the Colorado primary, Republican primary, because he engaged in the insurrection. And if you're an originalist, if you're a textualist, which is what these so-called right-wing U.S. Supreme Court justices say they are. They admit it. They're proud textualists and originalists. Well, read the language. The 14th Amendment says, right, that having taken an oath to support the Constitution, if you then engage in an insurrection, that you are disqualified from running, just like if you were 25 years old, just like Arnold Schwarzenegger, you were not a natural-born citizen of the United States. So that's what's kicking around in all of that. And my prediction on that has been that one way or another, this will not result in Trump not being able to run in all 50 states, and not being able to run in the primaries in all 50 states. And I believe Trump will be able to run, if he's the nominee, against Biden in the general election. Now, how exactly the U.S. Supreme Court is going to get there is what's confounded people, because it does seem like our elections in America are, even for president, are state functions. Each state, somehow or another, through an election in that state on election day, but also through acts of the legislature. We saw that where Trump, in my opinion, tried to do the big steal, and get away with stealing the election when he ran against Biden. But there's ways that after the election, or in combination with the election in each state, the state legislature can act in certain ways. Remember, all kinds of people can act in certain ways, and you can say, well, that actually violated the federal Constitution. But Mark, most of them have been rejected, because pretty much the state sets the terms of the state elections, even for president. So it makes it difficult for the U.S. Supreme Court to say, wait, Colorado, as a sovereign state, did something wrong in how Colorado's Supreme Court decided under its law. It's interpreted for its law, the U.S. Constitution, to say, reading the text of the 14th Amendment, it says an insurrectionist cannot run, and therefore we're enforcing that in the state of Colorado. Having said all that, Mark, I just don't see it. I think that the likely ways that they will duck this issue, remember, they can't duck it, they have to decide it. If they now, one thing, Mark, is that the primary ballots have gone out because they took some action. The U.S. Supreme Court took some action. Colorado's Secretary of State has sent out ballots that list in Colorado Trump, as well as Haley, as well as the other people who want to be the Republican nominee in Colorado. So the ballots have gone out. So there's a way, I guess, the Supreme Court could kind of like Bush v. Gore, and then say, this doesn't apply to anything else, but here's our ruling right now. Let the ballots go out. Or primaries aren't covered. Mark, there's a way to say primaries really aren't covered. They're kind of different. And finally, one of the provocative arguments, I don't know if it's a winner or not, but a provocative argument is that you basically can keep running. You have a federal right, they might say, to keep running in every single state. And then if you're going to not be allowed to actually assume the presidency, that one's up to the Congress. And the idea would be, let's say what Schwarzenegger could have done. Schwarzenegger could have run in every state. Everyone said, my God, you're not a natural born citizen. His lawyers would have fought that off. If he'd have won the election, then Congress would have had to decide, right, on January 6th when they certified the winner. And we could have a debacle like we saw on that January 6th with Trump, but hopefully that will never happen again, or anything like it will ever happen again. But it seems to be politically, this is my political commentary, not so much legal. That's a terrible system to have. Can you imagine if somehow Trump had either won or lost, but it was close, and now the Congress has to decide whether to finally disqualify Trump because he engaged in insurrection from assuming the presidency the next time, that everything else is sort of not final. Trump can keep running and running, and then eventually it's up to the Congress whether to seat him as president. In other words, whether to count the votes from or not, or to say, you know what, we're not counting any of them because he engaged in insurrection. I can't imagine the Congress doing that. And so Trump may feel like no matter what happens, keep running, keep fighting, and the Congress on January 6th, 2025 will not bar him from assuming the presidency. So as I've always said, and I'll start my monologue, okay, organize, vote. Don't assume any of these things are going to stop Trump from running in all 50 states. Organize in all 50 states and vote if you don't want him to be the president again.
Well, I would say this too, just in general, based on what you've just said. And I always think that we've gotten fat and happy in America with a system that's pretty well flawed, but it's kind of worked or whatever. It's only been in the last, few cycles, presidential cycles, that we go, wait a minute, you realize the fragility of the system, the way you describe it, that essentially, as I understand it now, because it is state by state and there's a certain sanctity to the way that the states are treated. Like, we really can't get involved in the way they do their voting. And I know that there's some exceptions when it comes to, every civil rights and this sort of thing. But that a Secretary of State could essentially invalidate the vote if they don't like it, or other officer alongside Secretary of State with the power to essentially invalidate the people's voice in the state. That's kind of what you've said, David Katz.
I think every state has a mechanism so that you can challenge the Secretary of State. It's still administrative action that can be challenged in the courts. And one of the things that's interesting about this case, Mark, is it's all happening so fast. And I think that the U.S. Supreme Court is really going to try to find a way to let these primaries go forward. And then I think there have to be challenges to the general election that are made as timely as possible, and to give the courts as much time as possible. But I just have a feeling, and I don't mean to depress anyone, that at the end of the day, and I don't know if it's exactly how they're going to get there, but at the end of the day, the U.S. Supreme Court will not issue a ruling that leaves things. Every state can do what it wants to do. All 50 states, it all depends what the Secretary of State decides and what each state court decides. I do think that there's a couple of things wrong with that, sort of like they thought in Bush v. Gore. The only, I think, plausible defense of Bush v. Gore was not a legal one, but a policy one, that things were going to spin out of control unless the recount stopped and unless that election got called for one or the other. I think I don't agree with the decision. I think that's the only plausible defense for it. And I think that the U.S. Supreme Court is thinking, is this going to be a good decision? Is this going to be good for the country? And that's, I guess, the urge for them to think of what's good for the country, and not so much the legalisms, because the legalisms, Mark, as I say, if you're an originalist, you're a textualist. Did he engage? Well, he had due process in Colorado. He had a trial, and he said he didn't engage and that this didn't constitute an insurrection. And as the, I think, Maine Secretary of State said, kind of citing what happened in Colorado, she said, I know no Secretary of State has ever kept a presidential candidate off the ballot, but we've never had a presidential candidate who did anything like what Trump did. He encouraged his followers to come to Washington, D.C. He said it's going to be wild. He encouraged those slates, which were phony. He tried to vault that lower official at the Department of Justice into the top job so that official could issue a fraud alert when there was no fraud. He did all those things down in Georgia, which he's being prosecuted along with his henchmen. Are there any henchwomen? I guess there are, down there in Georgia. And then he gave those incendiary speeches at the Ellipse. He said, fight like hell. He had Giuliani give that speech. That was also inflammatory. And
well,
then,
to a mob that he knew was armed. I mean, there's chapter and verse on this. And then you have, and this is what worries me, we got to wrap up, David Katz, but, he had a phalanx of lawyers, Sidney Powell and Eastman and all the rest who are ready to do the dirtiest of work for him. And I think that may, and we can talk about this next week, that may be the future. I mean, I think the notion, that's why I say you've met your moment. I think the courts, that's increasingly going to be where this next presidential election ends up. And then you end up with it being kicked to Congress, and then it becomes a GOP victory because it just goes every state gets one vote. We can talk about that next time. But I just, David, I see, more American time spent in a courtroom than ever before when it comes to these elections. So,
well, I think Trump is going to try to use even these federal court hearings. He supposedly wants to go to the argument in front of the U.S. Supreme Court if they grant an argument, and he'll be out there posturing and trying to turn that to his political advantage. And, this one may even turn more to his advantage because this is not the Colorado Supreme Court decision, banning him that's going up to the U.S. Supreme Court. That is not criminality. He's got 2 federal criminal cases, which are incredibly serious. He's got 2 state criminal cases against him, and appearing in front of them, you kind of shake your head and think, my God, this guy's campaigning for president, standing in front of his own criminal trial. Do people realize that? But now he'll be standing in front of the U.S. Supreme Court, right, in what's a civil administrative dispute, and he's going to try to play this for all it's worth. So my last words: vote, organize, don't wait for the courts. You can wait to hear what David Katz has to comment about the courts, but don't wait for the courts to stop Trump. If you want to stop Trump, vote, organize. Tell everybody in a swing state to get involved, go to the polls.
The great former federal prosecutor, now defense lawyer. There he is, a viewer having merged Nostradamus and David Katz. We call him Katzadamus, and his predictions are pretty accurate. So we look forward to next week. Thank you, David Katz.
Great to be with you. Very accurate so far. Very accurate.
So far. Very impressive, sir. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.